Good morning, good afternoon, depending on where you are joining us from. We are here today with Tricia Meyer and Melody Ashby with Meyer Law Firm. Welcome.
Thanks for having us.
Always a pleasure to have you all on. We learned so much about why it's important to have your contracts in order when you're dealing with your business. So
Absolutely. There are so many different relationships within your business, and it's important to have contracts that are tailored specifically to it. So we'll go through all of that today.
awesome. Well, before we get started, I always like to ask everybody where you're at and what the weather's like for you. So, Tricia, why don't you start? Where are you at?
I am in northern Michigan and it's
Okay.
snowy today.
Oh, wow. What's the temperature?
It is 34 degrees.
Okay, okay. Well, that's perfect temperature for snow. How
Yeah,
about you, Melody?
it is. I'm in Chicago. It is
Okay.
about 31 degrees and also snowing.
Wow. So it's actually colder in Chicago than in Michigan. Well,
Yeah.
I think the cold snap has hit us as well. I'm in South Carolina and it is currently 48 degrees, but it is not snowing. It is a beautiful day outside, just a little bit cool. So awesome. Well, I am super stoked to learn all about the contracts, learn all about why we need contracts in our business life, how they can protect us. So, Tricia, do you want to get started?
Absolutely. All right. So before we get started, I will just give you a little bit of background about Meyer Law. We are a woman-owned law firm helping startups and growing companies and large corporations with transactional matters related to their business, really the legal framework of their business. So that's corporate contracts, employment, intellectual property, fundraising, and privacy. We're really entrepreneurial, and I like to say that we have a transparent, common sense philosophy when it comes to billing. We do as much of what we can on a fixed fee for early stage and scaling companies. And then we also work on an hourly basis in situations where it's necessary. We also offer in-house general counsel packages and outsourced general counsel packages for those companies that are scaling and growing and need some more consistent support. We have offices in Chicago, Denver, Los Angeles, and Traverse City, and we're really passionate about entrepreneurship and mentor at a lot of incubators and accelerators across the U.S., like 1871, Techstars, the Commons on Champa, and WeWork Labs. We've also been lucky to be recognized for several awards over the past 13 years. Most recently, we were recognized on the Law Firm 500 for the fourth consecutive year as one of the fastest growing law firms in the US. And then late last year, I was recognized by Forbes on the Next 1000 list.
Excellent.
All right. Now, Melody Ashby's been on the team for 10 years now and is with me today. And we'll start it off by talking about founders agreements.
I want you to go back one to the slide though. Show your clients
Oh,
one more
sure.
time. How can I get IT Business Group on there? Because we're a client too. We've been a proud client for a long time.
Yeah, we'll put you on there. You got
Awesome.
it.
So yeah, as Tricia mentioned, the first thing that we'll just talk about is just founders agreements in general. So if you have a partner in your company, then you should have a founders agreement. And so what is essentially a founders agreement? It sort of acts like a prenup. You're entering into this business marriage and it acts as a prenup for the founders in the company. And the intent of it is to really establish your intentions and expectations in relation to how you want to run the company and decisions that will be made as you continue to do business together. At the outset, what it does is it really encourages open and honest discussion because it acts as a roadmap. You have to sit there and work out all of these worst case scenarios. And it's nice to do so when you're getting along as opposed to potentially if you're in a dispute down the road, you're obviously not going to see eye to eye at that point in time. And then it also confirms vision. So you meet together, work through, again, some of the worst case scenarios of what would happen if there is a business termination with your co-founders and put it in paper. The goal would be, of course, that your business is super successful. You never have a dispute with your co-founders, and then hopefully you never even have to go back to the four corners of the document. More often than not, though, there is going to be some type of dispute. Unfortunately, it is what it is in today's world. You know, people change, vision changes. You know, sometimes there's needs to switch companies or do something else. And having a co-founders agreement essentially allows you to set forth and predetermine what would happen in those scenarios. And so a founders agreement is just a general term that we use, but if you have a limited liability company, you would have an operating agreement. If you have a corporation, then it would be a shareholder agreement. So terminology is going to be a little bit different depending on the type of entity that you've set up. But essentially what it does is it'll cover all of the things that you need to decide. So how can you avoid co-founder conflict is by getting a founders agreement in place. Ultimately, you'll talk about your roles, what are each party's responsibilities, how much ownership will each party have, how does that equate to voting? Voting can cover something as small as, you know, hiring decisions or, you know, ordering office supplies all the way up to selling the company or adding in additional equity holders. It would also cover off transfer rights. So if I am going to terminate my business relationship with the company, what happens? You know, we consider there to be quite a few different types of termination events. It could be a voluntary termination. Maybe I want to sell my equity to a third party. What happens in that scenario? Does the company have a right of first refusal? Can they buy back that equity before it gets transferred to a third party? Another type of transfer scenario would be an involuntary transfer. It could be a death, a disability, it could be divorce. What if my ex-partner, you know, in the court is awarded my equity in the company? You know, do you really want the company to be in business with your co-founder's ex-spouse? Likely not. So you want to allow for scenarios where you have a right to, you know, repurchase the equity before it gets transferred to third parties. Or there could just be a business termination in general. Again, maybe I need to go and do something else. I no longer want to be in this line of business. Or maybe I'm not performing and I'm being terminated for cause. What happens and how are you going to actually value the equity, and what are the repurchase rights for the company or the other shareholders or members? So, you know, you want to get a co-founder agreement or founders agreement in place sooner rather than later, because obviously, again, especially if you're just starting out and starting a new, you know, managed services business and you want other partners to come and join you, and you're each going to have an equity and play a role in the company, then get it in place as sooner rather than later, just to avoid, again, that co-founder potential conflict. You know, unfortunately, disputes are the norm, and some of the high profile cases that we're all aware of, all with Facebook, Snapchat, and Square, you know, all of those multi-million-dollar lawsuits and settlements really could have been avoided if things were put in writing to begin with.
And there's so many things you just brought up that people, I guarantee you, when they start their operations and their business, they don't think about all those things in advance. Well, what about it that that's a partner's ex? And God, I just thought about that. I'm like, that's why it's so important to hire an attorney to get all this stuff up front.
Exactly. I mean, especially when you're starting a new business, you don't know what you don't know, but we know what you don't know. So
that's awesome.
We've seen all of those disputes. So, you know, I definitely think it's beneficial, and it's the one agreement that I feel most companies, especially when you have a co-founder, they kind of put on hold. You know, obviously you're trying to build the business and put resources elsewhere. Just don't neglect this part of the business because it's really important.
Awesome.
In relation to founders agreement is also, I wanted to briefly talk about equity and stock grants. If you're planning on giving any equity to any of your service providers, whether you have a CTO, whether you have an advisor, whether you're hiring employees, and maybe you can't pay them market salary, so you want to compensate them by giving them equity in your company, the founders agreement covers the overarching, you know, how things will be made in the company. But you'll also want to, whenever you're hiring folks, you'll want to get contractor agreements and employment agreements in place. I won't go into detail, but that will document the services aspect, because we'll get into these documents a little bit later. But more importantly, when it comes to the actual equity award, you want to make it subject to vesting. So what do I mean by vesting? Vesting is essentially where you're granting the equity to your service provider, employee, advisor, whoever it is that you're granting equity to, but you're going to make it subject to certain conditions. So they're not going to get 100% of that equity on day one. They have to earn it over a period of time. And so you'll often hear with vesting conditions, especially in a tech startup, a traditional tech startup would have a 1-year cliff over 4 years. What that essentially means is for that first year, no equity actually vests or transfers hands. After that first year, a portion of it will vest, and then it typically vests monthly thereafter over 4 years. That's a traditional time-based vesting. You could also based on milestones, maybe getting a certain number of customers. It could be a revenue threshold. If you are going to do milestone-based vesting, it's absolutely fine. You just want to make sure that it's objective criteria. Oftentimes when I meet with clients and see that they're doing milestone-based vesting, it often becomes subjective criteria. And I'm like, well, how do we know? Who says when this actually happened? So if you are going to be granting equity, make sure that you're documenting what happens, make sure you're documenting the vesting terms. And the whole point of the vesting terms is to make sure that your service providers are on the same page with you, moving forward and working toward the same goal. Also, it gives some service providers, particularly employees, some ownership in the business. You know, they want to see the company do well if they have equity in the company as well. So all of that comes into play. But you also have to think of, again, those worst case scenarios is what happens if you grant equity to an employee, but then you terminate them down the line. What happens to that equity? Do they get to keep it? Do you have repurchase rights? How do you value that? So again, it comes back to the founders agreement, because once the equity vests, they should be bound by the terms of your founders agreement that set forth the transfer rights, the right of first refusal, how you're actually going to value the equity for repurchase purposes. You know, it's just general things that you want to think through when and if you plan on granting equity in your company to any employees or contractors or advisors.
Very good.
Next up are confidentiality agreements. So oftentimes you will be, engaging in discussions with other parties that aren't, within your business, whether it be for strategic reasons, maybe they're a customer, maybe they're a vendor. And in those instances, before you enter into a main agreement with them, prior to entering into any discussions, you should enter into a confidentiality agreement or a non-disclosure agreement. It means the same thing. But essentially, it's a document to protect your confidential information and describe how the other party can use it. You really want to make sure that it's tailored to your business. You want to make sure that there's a clear purpose in there describing why you're providing confidential information to them, and if they're providing confidential information to you, why they're giving it to you as well. If the purpose isn't clear, a court may throw it out, and you don't want that to happen. You also want to make sure that your definition of what constitutes confidential information is broad enough to cover all of the information that you would share with this other party. Sometimes if somebody presents a non-disclosure agreement or a confidentiality agreement to you, there will be a requirement to mark things as confidential. You never really want to agree to that, because what could happen there is you could disclose something that's confidential, forget to reduce it to writing and mark it as confidential, and then all of a sudden they wouldn't have to treat it that way. So always strike any requirement that you have to mark things as confidential, and instead it should be what a reasonable person would consider to be confidential should be deemed to be confidential. And the courts look at that under this reasonable standard, and that's generally speaking what should be done instead of marking it as confidential. You just don't want to put yourself in a position of accidentally disclosing information. You also want to make sure that the term of the agreement will cover the period of the discussions, and then the obligation should extend beyond the term. So if it's a 1-year term in the confidentiality agreement, maybe you want the obligations to extend 2 years or 3 years or 5 years after the end of the agreement. So something for you to think about.
Okay.
It's also important to protect your trade secrets. Trade secrets are those things within your company that are known by few. So, things, if you're a tech company, maybe related to your algorithm for your SaaS platform, or maybe it's the way that you engage your clients, or, you know, if you're a food company, maybe it's your recipe. It's really all about protecting that information and only limiting it to those that need to know it within the company. You wouldn't want to disclose that to everybody within the organization, but rather only those that need it in order to do their job. If you license your trade secrets, you want to make sure that you have a solid licensing agreement in place, putting restrictions around what it is that they can and cannot do with it. You also want to make sure that you're training your team regarding best practices around the use of confidential information and what to do if there's a breach, and implementing procedures around that. And again, the NDA and really all of your contracts should be tailored to your business. Every business is unique because everybody runs their business in a different way. In addition, people have different risk tolerances. We have some clients that want everything buttoned up, like every T crossed, every I dotted. They hate risk. They want nothing to do with it. We have other clients who are like, just, you know, minimum bare bones, like we don't care about the risk, you know, just cap our liability. So it really, your agreement should reflect your risk tolerance, and then obviously the specific nuances related to your business. Otherwise, you're using contracts that likely aren't protecting your business, and you just don't want to put yourself in that position to clean up a mess after the fact.
Good to know. I have heard that term so many times, risk tolerance.
Yeah. Yeah. Next up, another important type of agreement that you have within your business are independent contractor agreements. So whether you're bringing somebody on your team, you have to decide whether they're an employee or an independent contractor. To decide which bucket they fall in, you look at the level of control that you have over them. The more you have control, the more likely they're an employee. The less you have control, the more likely they're a contractor. In the event you determine that they're a contractor, it's important to get an agreement in place that sets forth a very clear description of the services that they're going to be providing to you, along with timelines. Not a vague description of, you know, they're going to provide services to us. Like, get really granular with your descriptions, because it'll be hard to hold somebody's feet to the fire if they're not performing, if your descriptions aren't adequate. And then also, clients sometimes forget to put timelines around things. And so they're sitting there waiting forever for something, but they don't really have any clear timelines in the agreement around the expected deliverables. So it's important to include not only a robust description of the services, but also a timeline for the deliverables. Acceptance testing is also important to make sure that what the contractor is delivering to you is in line with your expectations. And so putting a process around where you can essentially test the deliverables to make sure that it's in line with your expectations and any criteria that you've agreed to, and that there's a remedy. If not, if it doesn't meet the criteria, then they need to go back and fix it and then present it to you again. And maybe if they still can't get it right, then maybe you get a refund of fees. There are certain remedies and a process that you should definitely put in place to make sure that you are getting what you expect. You also want to make sure, obviously, that you're protecting your confidential information. And then one of the most important things is ownership of intellectual property. So the default under the law is whomever creates it owns it. And so to the extent you have somebody create something for you, a logo, they're developing your website, they're developing some strategic plan, your handbook, whatever the case may be, the default under the law is whoever creates it owns it. And so you want to make sure that they're assigning those rights over to you in the contract, making it very clear that you own what's being created. It's also important for you to know about any pre-existing materials that they've incorporated into what it is that they're providing to you. Meaning, if they've created something before and they're embedding it or incorporating it into the work that they're providing to you, you need to know that, because you don't own that piece that they're putting in there, and you need to make sure that you have really broad license rights to use it, so that way it doesn't impact your go-to-market strategy. It's also important, especially in the tech industry, that you make sure that you have a good understanding of any third-party integrations that are being included within your product, and any open source, because with those items are included terms that you need to abide by. And so you need to know what they say and make sure that it doesn't restrict, what your vision is for your business and going to market. Because sometimes if the terms are too restrictive, you might choose to find another product that doesn't have as restrictive of terms. You also want to make sure that in these contractor agreements, you have an indemnity, meaning that this contractor will step in your shoes and make you whole if you suffer some kind of damage based on something that they've done. So let's say you've hired a contractor to create a logo for you, and they ripped off somebody else's intellectual property and embedded that into your logo, and you didn't realize it. And then that company comes after you and says, hey, this mark right here, you're infringing my rights. This is the same, looks the same as mine. They would have to make you whole and stand in your shoes, so that way you weren't suffering any damage from that. It's really important, especially when somebody's creating designs for you and logos and, intellectual property, things of that nature. Next, you want to make sure that you're capping your liability and that their liability is unlimited. So you obviously don't want your liability to be unlimited under any contract, only in maybe certain situations, if depending on your risk tolerance. But for the other party, you want to make sure that you can go after them if they engage in gross negligence or, they do something really bad. You don't want their liability capped. So you want to make sure that you address that properly in your agreement as well. And then lastly, it's very important to look at termination. How can the parties terminate? Can they just walk away by giving you a day's notice, or do you need 30 days notice? Or do you need them to stick around and finish the project, and maybe they don't have the right to terminate for convenience? Similarly, what's your right to terminate? Can you just walk away for whatever reason? And if so, how much notice would you provide? Or can you only walk away if they breach? So thinking through those things and then what happens, the effect of termination, is really important in these contracts as well. Some common mistakes related to agreements in general is, people just fail to get agreements in place. They hire people, they don't realize that they need agreements. And in those cases, you can fix it on the back end, assuming you still have a good relationship with that party. There are ways to do that within the contract, but it's just one more hurdle that you have to, climb instead of just doing it right from the beginning. Next is failing to adequately detail the services and include timelines, which I've already mentioned. The next is intellectual property created prior to company formation. So to the extent that anything's been created before you actually set up your legal entity, then you need to make sure you're assigning the intellectual property from yourself over to that legal entity, because all of the intellectual property should reside in your business entity. I think oftentimes companies also minimize the importance of intellectual property. They just don't understand how important it is. It's one of the most valuable assets of your business. So it's definitely something that you want to protect, and you make sure that you're doing right, because it's one of those things that if you don't, it does end up costing you more in the long run, and it's just not worth it. And then lastly, another common mistake is just failing to understand what intellectual property you own versus what you license. And I kind of touched on that. If you are licensing IP, you want a really broad license, and you want to make sure that you really understand the terms related to it to make sure it doesn't impact your business, and own as much of, the IP as you possibly can. So that way you're not up against any restrictions.
Excuse me. So in line with hiring documents, as Tricia mentioned, outside of contractors, if you've classified your service provider and they need to be an employee, then you similarly need to get corresponding documents in place that detail the employee's role, their start date, salaries, and related responsibilities, to whom they might actually be reporting to within the company, as far as their responsibilities are concerned, as well as potential reviews. In an employment agreement, typical terms that you would cover off would be protecting confidential information. As you can probably see, that's a theme throughout. You always want to have terms in relation to protecting your confidential information within your company. You also want to cover off assignment of IP and inventions. Particularly what happens with employees is typically what the employee creates for you. Usually you'll own as far as from an intellectual property perspective, but it's still important to set forth parameters around the transfer of that, whether the company needs assistance with prosecuting or filing for any IP rights and any related inventions. What happens is, from an employment standpoint, various states have employee patent acts that might limit what you as a company might own. So for example, perhaps it needs to be limited to only IP that's created using the company's resources or using the company's confidential information. At that point, the company can own it. But if an employee is doing something completely on their own time, it's not related to the company itself, they're not using the company's resources, and it doesn't relate, again, to any line of business or anticipated business of the company, then usually that would be excluded from what you as a company may be able to own. So you just want to set forth clear parameters around that and what it is that the company, again, will own. And then termination expectations. Will you require the employee to provide notice in order to terminate? Will you offer severance in the event that there is going to be a termination? I would say that usually severance would be kept more so for higher end, maybe C-level exec employees. It's not necessarily always included in an employment agreement or offer letter, NDA combo, whichever route you go, but it's still something to set forth. And what happens upon termination, it's going to be important that you set forth state-specific considerations when it relates to termination, when you're actually required to pay that final paycheck, whether accrued but unused PTO, pay time off, is included in that. Every state varies about what they consider as part of that consideration and I guess compensation in general. So make sure that you're looking at the state laws where the employee resides. Some other considerations that might be included in your employment agreement would be around restrictive covenants, such as a non-compete, non-solicit, or non-disparagement. So a non-solicit essentially would prevent your employees from trying to solicit, work with, hire other employees or maybe contractors. It could be non-solicitation in relation to working with customers as well. Non-solicit, I often feel, is usually more important for companies than non-competes, but both could equally be important. Again, with all restrictive covenants, you have to look at state-specific laws. All of these need to be reasonable. It needs to be limited in time, geographic location in order for it to be enforceable. Some states, a non-solicit, non-compete will not be enforceable by law. So could be limited circumstances. So for example, if you're in California, non-compete's not going to be enforceable. If you're in Colorado, non-compete's not going to be enforceable except for in limited circumstances, similar with a non-solicit. So you need to look at what is important in your company. Is it something that reasonably relates to the company that you can claim? So for example, is it a trade secret that you're looking to protect? Is it just your customers that you're looking to protect? A lot of times courts will look at the business to make sure that the employee that has these restrictions, it makes sense for them. So if you have staff that is a cleaning crew and you have a non-compete, a court will look at that and say, what are you really protecting here? They don't even have access to your customer list based on their job duties. So, similarly with every contract needs to be tailored to the specific hire that you're bringing on. If you're looking at a non-compete, what is it that you're actually looking to prevent? Do you not want them to go out and create a competing business? Or is it more of a non-solicit that you're just trying to protect your relationships? So really think through what it is that you're looking to protect and look at the state-specific laws. Non-disparagement would be where, during the term of employment or thereafter, you are both agreeing, or maybe it's just one-sided, that you're not going to speak poorly about the company it's officers, it's other employees. And so again, state-specific considerations are super important. I can't stress that enough because every state is a little bit different in relation to all of these restrictive covenants.
Okay, next up and this is the last type of contract that we will cover off today because it's an important one, and it's customer contracts. So in your customer contracts, it's so important to structure it properly. You know, do you need a traditional version for your type of business, or can you use a click to agree version, or does it need to be some hybrid version where maybe you have an order form with a link to terms and conditions? I think really thinking through the most efficient way possible to structure your contracts, all of your different contracts, is very, very, very important, because as you grow your business, your time's just going to become more and more limited. And so just creating efficiencies from the onset is really important. You also want to make sure that you tailor it to your business. As I've already mentioned, different risk tolerances, everybody runs their business in a different way. You also want to make sure that you're not using any proposals. Oftentimes companies will use their proposal as their contract. The problem with that is, in the proposal, there's usually so much marketing wording that you wouldn't necessarily want to contractually bind yourself to. So it's okay to use a proposal during like the sales process, but then when it comes down to like the four corners of the document that you're agreeing to, it shouldn't include any of that marketing wording or anything like that. So steer clear of using your proposal as your contract. You also want to make sure that you're protecting your intellectual property. So to the extent you're allowing your customer to use your intellectual property or any third-party intellectual property that you're using on behalf of the third party, make sure that you're protecting it and putting the proper terms in the agreement in the event you need to, seek certain remedies if they're doing something wrong with the IP. Same with confidential information. Again, if you're sharing your confidential information with the other party, you want to protect it. Similar to what I was saying before about the confidentiality agreement, in this situation, it's just a section within the broader agreement. And sometimes our clients will engage in like pre-discussions with customers, and they'll want that NDA in place beforehand. Other times they don't really engage in those discussions until after they sign on the customer, in which case then you can just, you can skip the NDA step and just make sure it's included in your customer agreement. You also want to make sure you're limiting your liability. In very few scenarios would you want to go on the hook for unlimited liability, because one bad contract could sink your company. And then when in doubt, get a risk assessment. Sometimes as you scale and grow, other companies will force their contracts onto you. And we see so many companies just signing those things as is without really understanding the implications. So really having a lawyer look at it and review it to at least point out the risks and make recommendations will save you a lot of heartache down the line. And that's all that we have for today. But I'll also say that, we're at the end of the year, which is crazy. And it's always great to do a refresh at the beginning of the year for all of your contracts, just to make sure that they all reflect how you're doing business and your current practices.
Tricia, I want to ask you one question. I have been guilty of it myself prior to meeting you, because now I just send them to you and tell you, hey, what am I signing here? Help me out. But that last point you brought up about, as you get bigger and you'll have companies that send you their agreements, and be careful not to just sign those agreements. Why do you think that the majority of people who aren't properly advised by their attorney just go ahead and sign those? Is it convenience?
There's so many. Convenience. They're in a rush. They want to sign on the customer until the customer becomes a problem down the line. And then they're trying to, get out of this agreement that's so one-sided against them. I think it's that. I think it's they don't have the right lawyer partner. They don't have the right partner. There's a lot of reasons, I think.
Well, prior to meeting you and your firm, I can tell you, I was that person. I would just say, "Oh, well, I've got to sign it. They want me to sign it. I'll go ahead and sign it." So, but
Yeah.
like you said, you don't know what you don't know, and be careful because you could be putting yourself in unnecessary liability. So, excellent information. So, Tricia, what is the best way? I guess we've got it all right spelled out in front of us, but if anybody is watching, any business owners, and they want to engage your firm, just reach out, just send an email to you or Melody on the screen
Yeah.
there.
And you can
Okay.
go to our website at meetmeyerlaw.com, or you can reach out to us on Instagram or TikTok. Love Your Lawyer is our handle.
Awesome. So you're on TikTok as well?
We are.
I watch TikTok. I consume it, but I don't create in TikTok. So
Mhm.
I find it a challenge. But then I look at some TikToks and I'm like, they did a beautiful job. There's very few technology companies on TikTok, so I'm still trying to figure out the angle for that. But if
Yeah.
you are doing it, my hat's off to you. So that's perfect. So
Thanks. I love TikTok.
it is a time consumer, that's for sure. So
It is. Yeah.
awesome.
Right.
Well, listen, I appreciate y'all taking the time to meet with us today and give our audience some great advice about, why it's so important to team up with a great law firm like Meyer Law. So, thank you again. We'll have to do this again shortly.
Absolutely. Thanks so much for having us.
No problem. Y'all enjoy the rest of your day. Thanks.
You too.
Bye-bye.
Bye-bye.